I'm Lisa Rubin, and on this episode of Can They Do That, I'm joined by three of those leading the legal pushback against the Trump administration, state attorneys general. I'll go from my left to right, Kwame Raoul of Illinois, Matthew Platkin of New Jersey, and Keith Ellison of Minnesota. Welcome to Can They Do That?
Thanks to have us.
Thank you.
Thank you.
So I like to start off every episode with a sort of lightning round of sorts. I'm going to pose the same question to all three of you in order, and then from that point on, we'll be off to the races, and you probably won't get the same question twice. But for each of you, for many decades, states' rights were the rallying cry of the political right and the conservative legal movement. Clearly, you three and the other Democratic attorneys general with whom you've been bringing litigation don't see it that way anymore. Why should Americans of all political stripes care about state sovereignty, which is a concept that many people, particularly on the left, haven't thought a lot about in the space of thinking about threats to democracy and the rule of law? Attorney General, I'll start with you.
Well, first of all, the states and the state governments are most connected to the citizens of the state. And so we touch the citizens on everyday issues. And so having that autonomy to govern and not be preempted by the federal government or commandeered by the federal government is important for us to respond to the day-to-day needs of our constituents.
Attorney General Platkin.
I think it's fair to say that today, your rights and privileges as an American citizen vary based on what state you live in. So if you want to be free from gun violence, if you want to make sure you have access to reproductive health care, if you want your kids to get a quality public education, all of those are meaningfully different depending on whether you live in a state, frankly, with attorneys general like us or not. And so that when they created the Constitution and gave power to the states on law enforcement, on education, in a whole range of areas, healthcare. This is what happens when the federal government gets out of that space, and we are standing up for those rights.
Is it fair to say then that you think that state sovereignty is important when the federal government cedes its role as an enforcer of fundamental and civil rights?
Absolutely. This is the first time in the history of the Department of Justice since 1870, which was created, as we know, to protect civil rights of Black Americans fighting the Ku Klux Klan, that they've said they no longer care about civil rights. So it falls on states like ours to stand up and protect you. And that's what we are collectively doing.
Attorney General Ellison, what would you add?
Well, I'll just add that there is an important role for the federal government to protect rights of everybody. Your right to equal protection and due process shouldn't depend on what state you live in. But at the same time, we do have different regional, cultural norms from different state to different state. And it's appropriate for states to be able to be that laboratory of democracy, to try some things. And the sensibilities of people do vary. So state sovereignty means that in Minnesota, we get to have marriage equality if we want to. We get to let people vote after they've served their time in prison, even if they're still on probation or parole. We get to do things in some other state. They may want to do some things differently, but our local sensibilities tell us that these are the right things to do. And there should be enough variation and flexibility so that the federal government just can't trample all over the states. But at the same time, there are things that we do need the federal government to do. And sadly, it's not really doing them nowadays. But state sovereignty is key so that we can try new ideas and other states might adopt them if they work and not if they don't.
So I'm going to pose this follow-up question to you. What Trump administration policy or set of policies do you think at this point poses the greatest threat to the rule of law and or state sovereignty?
The usurpation of the National Guard in California, to me, is the big, ugly threat to American democracy. Because if he could just say, in order to do, immigration enforcement, we're going to send we're not just going to usurp the National Guard, we're going to send the Marines in to take care of stuff that state and local officials say, we got this.
Yeah.
I mean, this is not the first time there was a protest in LA. I mean, LA knows a little something about managing a protest. The local officials, law enforcement, they have it under control. But Trump says, no, we're going to dive in. I think that the fact that he can spread this anywhere, the fact that you can have people pointing bayonets at Americans because they, want to protect their immigrant neighbors and peacefully say so, I think that's very scary.
I don't disagree with that at all. Attorney General Platkin. I almost called you Congressman Platkin because I was thinking about the Attorney General's former life.
Don't get me in trouble.
But let's talk about Congress right now. You guys have spent some time, each of you, testifying before Congress about the work that you're doing with other Democratic state attorneys general right now. What do you see as Congress's role in fighting back against the lawlessness or unconstitutionality of the Trump administration's actions versus your collective roles? And if that's dependent on the fact that Congress isn't acting, tell me that.
Well, I think our role is to protect our residents from harm. And that's what we do every day, no matter who is trying to harm our residents. In this case, it happens to be a president and a federal administration that's breaking the law and hurting our residents. And a lot of what we're standing up for, frankly, in our suits, and this was talked about today, is Congress's authority, right? When they created the Constitution of this nation and said we're not going to have a king, they vested the power in Congress to spend money, to pass laws. And the president has to follow those laws. Now, we've been largely successful in our suits saying if the Congress appropriates money and it goes to programs that people rely on, we can stand up to protect them. So I think what Congress did today is a big part of its job, highlighting the work that we're doing, talking about how we're collectively standing up for the rule of law. And our job is to protect our residents, which is what we do every day.
All four of us know the answer to this question, but I want to demystify this for our viewers. Why isn't Congress suing itself? Why don't people like Senator Durbin and Congressman Raskin bring those suits to protect their own constitutional authority to appropriate?
Because courts have said they don't have standing to bring it on their own. So we step in and stand and have standing, meaning we can bring a lawsuit in court to say that when Congress passes money so that people get health care or educational services or law enforcement, the president can't just decide on a whim that he doesn't want to spend the money, which is the core theory in a lot of our suits.
I actually disagree with the courts on this issue. I think Congress should have the right to take the executive to court.
And you mean individual members of Congress, you don't mean the body as a whole, right?
Well,
because that's the only way that they would have standing.
Right. A minority of the members of Congress, if they feel like there's a law that's not being followed, they should be able to test that in court. I believe they should. Of course, the law is as A.G. Plotkin said it was.
I want to come back to the National Guard, which Attorney General Ellison, you guys are giving me lots to trip over.
A lot of syllables.
I know. Attorney General Ellison touched upon. California has been the only state so far in a legal fight with the administration about the deployment of National Guard members because to date, it's the only place where the National Guard has been deployed. But of course, as Attorney General Ellison referenced, the memorandum that President Trump sent out empowers the Secretary of Defense to send the National Guard to any state. It sort of talks about the situation in California and in Los Angeles in particular as being sort of the predicate and the reason for it, but it's not limited to California. California has maintained in court that what the Trump administration has done to date has already crossed the line into violations of the Posse Comitatus Act, which for our viewers basically generally prohibits the use of troops for domestic law enforcement. You've talked about your family's own immigration journey, and in light of that, I'm interested in where you think the line is between permissible and unlawful uses of the National Guard or even other troops like the Marines with respect to either protest activity or immigration enforcement.
Well, I disagree with the Ninth Circuit, and I think the law sets out three situations: where there's rebellion, where there's an invasion, or where the federal government cannot carry out its federal duties. Now, the federal government's hanging its hat on that third prong there, but still believe that the National Guard is put into action with consent of the governor. And so I disagree with the conclusion that was raised there, but certainly I don't think that, notwithstanding some limited video shown in California, circumstances where the federal government could not carry out its duties. State of Illinois, we anticipate will be targeted because unfortunately, there's been an announced partisan
Correct.
Targeting of where they'll go next. And
you're referring to the president's tweets where he said that Democrat-run cities are basically on his agenda for where immigration enforcement is going to be next.
Yeah,
that's what you're referencing.
And I anticipate that means Chicago. Yeah. Fortunately, we have a police superintendent in Chicago who's demonstrated just last year with the Democratic National Convention, where there was the nation descended upon Chicago, that protests can take place and local law enforcement can handle it well. So we've already demonstrated that we can control demonstrations and so forth, yet without curtailing First Amendment rights. And so the notion that it would be enacted within the state of Illinois, that the National Guard or other branch of armed services would be let out into Chicago streets, would be outrageous to me.
I want to pivot from that to something we were talking about before we started, Attorney General Ellison, because you were saying that one of the aspects of the federalization of protest activity, immigration enforcement by using National Guard, aside from that, one of the things you find most disturbing is the use of masked ICE agents in these enforcement situations. And I can understand why you're concerned about that. There are federal regulations that say that ICE agents are required to identify themselves at the time of arrest or as close in time as practicable given exigent circumstances. And yet, again and again, we're seeing video of masked ICE agents, Border Patrol, people who are marked simply as police. It's not clear what agency they're with. What role do the attorneys general have to play with respect to that issue? Is there anything that you can do from where you sit to bring litigation, for example, about that?
Well, we can make a demand. We can argue that there's some aspect of due process of law that requires that legitimate law enforcement authority identify itself. Again, I've done a little bit of cursory research on this issue, and I don't know if there's any prohibition against ICE wearing masks, right? I haven't found the statute that says ICE can't wear a mask or anything like that. I don't think I should have to find that. I think it's just clear that in a society, a democratic society based on law, that people who enforce the law are carrying out a legitimate function unless they're not. And what I mean by that is governmental overreach, people operating outside the bounds of law. How do you stop a police state from emerging in a democratic society? Well, one thing you do is you have accountability in law enforcement. And that means that we should know who they are. Yeah. I mean, think about it. If you have a mask on, you could commit an act which everybody in law enforcement would say is illegal and improper. And yet you're never going to be held accountable because people don't know who you are.
Right.
So this is a real problem.
What I hear you saying is you're not sure if this violates the letter of the law, but certainly the spirit of the regulations that say you have to identify yourself would be antithetical to masking up in an immigration enforcement situation such that you can't be identified unless you're sitting there with a microscope over somebody's badge.
Exactly, Counselor. That's exactly what I'm saying. I mean, these folks, in order to be consistent with every norm of a democratic rule, you've got to be able to identify members of law enforcement. And if you can't, what does that say about the state of your democracy? It says that it's in jeopardy. This is what far right, this is what authoritarians do. This is, and maybe super far left too. I don't know, but it's not free. It's not freedom. And it's not a society where, I don't know who said it, but somebody said that in a free society, the people are not scared of their government's scared of them. But when people are wearing masks, they're scared of the government. They're injecting fear. I mean, think about it. This is also good for law enforcement, by the way, because one day they're going to run up on somebody who's not getting into your van without a fight, and in an open carry state or somewhere like that, you could have a catastrophic event, heaven forbid. So for the safety of everybody, we need law enforcement to operate in an above board way that demonstrates that they're willing to be held accountable by being identified.
I want to talk about another aspect of due process that you and I, Attorney General Platkin, have talked about before, and that's the fight over the president's birthright citizenship executive order. One of the things that I think when I talk about this on air and on shows, I frequently say to the people hosting me, yes, it's about birthright citizenship, but this dispute is also about something much larger, and it's about the power of lower courts to issue what we conventionally know as nationwide or universal injunctions. Can you describe for people watching for whom this goes over their head and their eyes are glazing over, Why should the public care about a lower court's capacity to issue an injunction or an order that applies all across the nation and not just in the district court that issues it, or applies even more narrowly to just the plaintiffs who have asked for it?
Yeah, well, I think the birthright citizenship case is the quintessential case to understand why nationwide injunctions matter. So we just had our argument in the Supreme Court, and the federal government tied itself in knots to not talk about the merits of what they were trying to do because they know they can't defend the blatantly unconstitutional order that the president signed. But they very clearly want that order only to apply in states that have attorneys general like us that filed a suit challenging it. And so think about that. If you're a resident of Pennsylvania, which is across the river from us in New Jersey, and you choose to go to Children's Hospital of Philadelphia to give birth instead of going to Cooper Hospital in South Jersey, your child's citizenship could be determined based on that hospital choice because of who's your attorney general at the given state where you give birth. No one has ever seriously thought citizenship was decided in that way. And yet here we are with the United States Solicitor General before the Supreme Court arguing exactly that. So why does a nationwide injunction matter? I think it matters if you live in states where you have people not standing up for your rights. Those rights are just as important if they're enshrined in the 14th Amendment of the United States Constitution. They're supposed to apply in all 50 states.
That's right. I think the birthright citizenship case has a third important.
Tell me about that.
It highlights just a blatant disregard for the Constitution. What I mean by that is the language is so clear in the 14th Amendment that the president would start with disregarding an amendment with such clear language that you are a citizen of the United States if you're born here and subject to its law. So plain in its language. We have a president who said few weeks ago that he doesn't know whether he has to follow the Constitution. I think the birthright citizenship case highlights the total disregard for the Constitution that this president has because the language is so plain.
Well, let's talk about that.
Can I add something on that?
Yeah, go ahead.
One, the president swears an oath before the country where he says that he will uphold the Constitution. So for him to say he doesn't know, well, when did he change his mind? That's a good question, I think. And the other one is that in 1898, the Wong Kim Ark decision was issued, and that one found that birthright citizenship was as we know that it is. But that was in the era of something called the Chinese Exclusion Act.
Yep.
This country was virulently anti-Chinese during that time, and that Supreme Court, the Plessy Supreme Court, said it says what it says. So I just think Kwame's absolutely right.
I mean, I want to be fair to the argument that they're making, one that I think is pretty tortured, but they are saying that the phrase in the 14th Amendment, subject to the jurisdiction of, can't possibly include all nationals of other countries, and that the case that you just invoked is really about where somebody resides or is domiciled, and that the 14th Amendment is not meant to universally convey birthright citizenship. I think the attorneys general have the better of the argument there. But yeah, we are living in something like the legal upside down when a 127-year-old decision that has never been questioned before is suddenly reinterpreted by a president and subject to an executive order. I want to ask something else about universal injunctions, if I can, for a second. And Attorney General Platt, will come back to you. Congress has been discussing whether or not they can apply certain carrots and sticks to make sure that judges can't issue universal injunctions in certain contexts. But it's not clear that they're going to do that. But whether or not it's the Supreme Court or Congress that does it, if courts can't issue universal injunctions, and I mean this outside or in addition to the context of birthright citizenship, is that a potential threat to the rule of law? Like, help me make that concrete to people. What does that mean, putting aside the citizenship context? If you can't have universal injunctions, how does that threaten what we know of as our democracy or the rule of law on which it rests?
Well, first of all, I didn't see Republicans in Congress having concerns about universal injunctions when Texas and other states were suing the Biden or the Obama administrations, as they did repeatedly. Look, I will say, I think I share the same concerns that Justice Kagan shares a number of folks on quote unquote our side share about universal injunctions. They should be limited. But there are clearly circumstances like the birthright citizenship case where national relief is important. Because think about it if it doesn't play out that way. We file a suit in New Jersey. 49 other states don't. That means their citizenship, somebody just happens to live in another state, they have to find the resources to get a lawyer, navigate a complicated legal process just to protect something that post-Civil War we came together as a nation and settled the debate on in the 14th Amendment of the United States Constitution. That's really a time when we shouldn't just apply something universally. That is effectively the argument against it. And so what are they doing now? Because they are not winning in court. And I think the Supreme Court, we'll see what they say, but I think they clearly, even in this case with respect to states, had some concerns about the U.S. government's argument. They're trying to change the law in Congress. And that is a really scary proposition for people in states that don't have attorneys general like ours to stand up for their rights.
Well, and I think that, and I don't know whether you agree with this, I'm curious as to your thoughts, that curbing the use of nationwide injunctions at a point in time where the legal profession itself is under attack, limiting the availability of lawyers, or at least incentivizing people to step away from the kinds of representation that would allow them to be represented in a world without nationwide injunctions, those two trends hand in hand make this whole enterprise even more pernicious.
I think so.
I
absolutely think so.
I think that's right. I mean, I think it was, I mentioned one of my high school mates, Arnie Duncan, earlier. There's another guy who went to my high school, John Paul Stevens, and he's the guy who said, who referenced Shakespeare's Henry VI.
Kill all the lawyers.
Kill all the lawyers. That it wasn't really meant to demean lawyers. It was meant to say that the first step towards totalitarianism was getting rid of advocates.
That makes you feel important, though, right?
Well, in many ways, lawyers, are when they say we're officers of the court, we're also agents of the rule of law. And so I think I've been reminded about how much of an honor it is to be a lawyer these days.
Let me ask you all a question, because before we started talking on camera, we were talking about how your roles have sort of two faces to them, right? You bring litigation on behalf of the citizens and residents of your states, but you also have a community-facing job where you go out into the community, you try to understand what is it that people are really concerned about and try to target your resources in those directions. When you're in the community, what's the number one thing you're hearing these days about the threats to the rule of law? I'll start with you, Attorney General Ellison.
The rule of law. I was in a church this Sunday talking to a group of folks. They asked me to come. I showed up. And on a very hot day in Minnesota, we had about 150 people in a room asking about, well, do the rules mean anything anymore? Is our country just going to be run by the whim of the president? And what does Congress mean? What do the courts mean? What does anything mean? If one guy, based on who donated to him, who gave him a $400 million plane or whatever, gets to do whatever they want to do. One day he likes Elon. The next day he doesn't. One day we have tariffs. The next way we don't. One day he doesn't like any immigrants. The next day he's going to make a carve out for agricultural and hospitality immigrants.
And then he's going to go back on it.
And then he goes back on
Right.
it. So that is the essence of what people are really concerned about. And this spans the globe. That's what people, that's what I'm being hit with. And of course we're dealing with transgender issues, immigration issues, diversity, equity, and inclusion issues, but the general prevailing sense of utter chaos and whimsical rulership, those are the things that.
Well, let me push back on that for a second with your own words.
Yeah.
When you testified before Congress, one of the things you said was that you tell people in your state that we are durable enough as a nation to withstand this presidency, or rather, nation is durable enough to withstand the threat that Donald Trump poses to our democracy if we are durable enough.
Right.
Who's the we in that calculation, and what does it mean to be durable?
Well, and durable means to be able to sustain knocks such as the president is doing to the United States right now in our government. And who is the we? The we is actually, in my view, the we is pretty expansive. It's the people of the United States. It's the Attorney General. We'd like to get some Republicans on our side. We really would. It's Congress raising the issues and having hearings like they did today. I want to commend them for that. And it's also, quite honestly, it's the press. Every politician knows that, we kind of go back and forth with the press, but it is deeply disturbing to me that he's going to cut off funding for PBS and NPR, challenging the licenses of different stations. I mean, who's going to shine the light on him if the press cannot criticize this guy? Punishing protests, that's the we that I have in mind.
Are we in a constitutional crisis, Attorney General Platkin? You and I have had this conversation before.
Yeah.
A couple months later.
Yeah, I think it's hard. It'd be impossible for me to say no, given that we've had the president, the vice president, the attorney general, and their representatives in court openly either defying or threatening to defy court orders. I think the Constitution and the people of this country are not going to accept that type of defiance. But to the question you asked, Keith, what are people concerned about? I think this concept of rule of law, or as Stephen Miller, I love, he calls it a judicial coup. No, they're already in charge. That's the way. That's the way the Constitution is set up. It's been that way since Marbury versus Madison.
That's right.
But what are people concerned about? And this concept that can be so abstract. Well, they're concerned about that the president, as Keith said, can wake up and change things that affect their lives arbitrarily, simply to punish for cruel reasons. I had a mom come up to me at my son's soccer game, almost in tears, because her son has autism. And she said to me, Matt, the only time I don't feel like I'm just going to break down crying is when I take my son to school and I know he's getting good care. And she said, can they really take his one-on-one aid away? Which is what they're, of course, threatening. I know Secretary McMahon doesn't know what IDEA is, but that's what IDEA funds.
Right. You're talking about the Individuals with Disability and Education Act.
Correct. So the rule of law says when Congress passes funds so that kid gets that aid that gives that mom a moment of peace, the president can't yank it because they don't like New Jersey or Pennsylvania or Minnesota or Illinois.
Well,
That's
let's
what the
talk
rule
about
of law
that for a
is.
second, because one of the things that you guys have been fighting about right now is about restoring or preserving existing sources of funding that, of course, were enacted by Congress subject to their annual appropriations process. We're about to go through that again. And in fact, right now, the president is pressing for the passage of his one big beautiful bill that might change a number of line items here. What happens to the fights you're fighting in a world where, let's say, IDEA funding, which is congressionally authorized, meaning there's a statute that says there's an Individual with Disabilities and Education Act, when those line items for the actual funding streams that authorizes are dissipated or evaporate from future appropriations bills, how then do you best protect the residents of your state who are demanding that the federal government continue to provide the services on which they rely?
Well, I think it's important to note that the lawsuits that we filed because the policies in the federal government's actions were pursued illegally. You talk about a dual role that we have. We have the role of the bully pulpit, and we have the role of filing lawsuits. We have to have standing, and there has to be harms to our clients, our states, the people of the state. If Congress has the audacity to carry these things out in the legal manner, yes, our playing field changes to some extent. That doesn't mean we leave our bully pulpit to the side.
But let's talk about the changes in the playing field. I mean, I have to imagine when I think about this movement that you three are a part of, with a fluctuating coalition of 18 others, Democratic attorneys general, right? There's somewhere between 12 to 21 of you and any number of these lawsuits. When you get together and you're talking about your strategic priorities and the things that are worthy of your investment of time and resources, in the event that that playing field changes, what does that do to the nature of your coalition, the litigation that you pursue? Putting aside the bully pulpit and not to diminish the importance of it, what does the future in court look like for folks like you if some of those funding fight opportunities go away?
Well, there's still a lot of things that we're going to be fighting about. If there will be some funding, and if he tries to conditionalize the funding based on our state rejecting or accepting his rules on diversity, equity, and inclusion, or what he calls gender ideology, then, conditionalizing those funds, that could be a potentially illegal problem.
Right.
But,
And it already has been. I mean, you
It already
guys have
has been.
recently won a victory
yeah.
and a suit against Secretary of Transportation where they tried to condition transportation funding on your cooperation with immigration
Right.
enforcement priorities. Is that a fair description of the suit?
Yeah. But those suits go on even no matter what happens with this bill, because it's still funding. We're still entitled to it. He cannot commandeer our state, and we will have those fights. We'll also they still have to be the law. Whatever he does, he can't operate in an arbitrary and capricious manner, or we're going to come at him with the Administrative Procedures Act. He's still, there remains a number of things we're going to continue to fight about, although some of them will change, as you point out.
I'm sorry. First of all, I think it's harder to do the things he's trying to do than they might have anticipated. Ronald Reagan couldn't end the Department of Education through an act of Congress. This president tried to do it through an executive order, an administrative action. Now they're going to try to change funding levels through Congress. We'll see what they actually get through. Not as easy to do something in a deliberative body as it is with a Sharpie.
Right.
But the second thing is, to the points that's been raised, the Constitution still places some limits on what Congress and the president can do, even with legitimate spending appropriated by Congress. And in fact, the lead state attorney general advocating for the current rule that limits Congress's ability to coerce states is none other than Pam Bondi, back in the Medicaid expansion case, which she led on behalf of 26 states.
Right.
So all we're asking for is the same thing she asked for as a state attorney general. Don't use federal spending to unduly coerce states into unrelated policy decisions that you have no authority over.
We talked earlier about this being a constitutional crisis. You're willing now to cross that Rubicon and say we're in it. So then let me ask you the question on the other side. How does it end? You first, and then let's go all the way down the panel.
The American people are coming out more and more every day. More people who've never been to a protest march in their life. There's research out there. There's a really awesome scholar by the name of, I think her name is Erica Chenoweth, and there are others as well, who studied like 400 or 500 movements where the society has gone from democratic to authoritarian and how people have tried to resist those. And she's found that when about 3.5% of the population says, we're not doing this, we're going to have democracy, then it's extremely hard for the authoritarian government to do what it's trying to do. So I think, yes, we're going to keep on suing, but I also think it's important for us to continue to communicate with the public and give people hope that we can protect and defend and extend our democracy. And because it really is, at the end of the day, it's about people power.
A republic, if you can keep it, it's up to the people, and we will continue to fight and make sure that their voice is heard. But it's up to the people.
Kwame Roll, the last word is yours.
Well, first off, I'm not surrendering the notion that we've reached that crisis stage. We are winning in court, and we are where there's not following of court orders. We're winning motions to compel. So we are winning. But I think I referenced in the hearing that Chief Justice Roberts, speaking to Georgetown law students, said that the rule of law is under threat and that we really need to amp up our civics education. I think what he was saying is what my colleagues have said. The people have to step up, and the people have to know that their Constitution that has maintained this American experience of balance of power and government is under threat, and that we did not coronate a president.
Well, on that no king's note, thank you to all three of you.